Good morning. I'm Dan DeRose with 19 News Now, coming to you from our digital desk. We're going to be taking you live into the Cuyahoga County Court of Common Pleas. You can see the man in orange right there is James Saunders, 56-year-old former, or probably going to be former attorney. This man has been convicted by a judge on a bench trial of voter fraud, voting in both the 2020 and 22 general elections in both Ohio and in Florida. He tried a number of excuses. He didn't know that the judge, that he didn't know about voter fraud, that he voted in two places. He also tried to say the judge didn't have jurisdiction in Ohio because he committed this crime in both Florida and Ohio. The judge sending a stern warning that Mr. Saunders' voice is no more important than the rest of us who vote. Today is sentencing day. Let's take you live into court now for the sentencing of James Saunders.
To engaging in any sentencing hearing, there was the matter of reviewing Mr. Saunders' determination of indigency, and then after the finding of guilt by the court, the defendant, Mr. Saunders, through counsel, filed several motions regarding that finding of guilt. So first, prior to addressing those motions, I had ordered the public defender to provide, pursuant to Ohio Revised Code sections 120.05 and 120.15D, their determination of indigency regarding Mr. Saunders for review. Mr. Sweeney?
Thank you, Your Honor. So just, obviously, Your Honor's familiar with the revised code section at issue here, but I also wanted to just talk briefly about what the administrative code provides, and that's Rule 120-1-03 with respect to how indigency is determined. So as an initial matter, anyone whose gross income is 187.5% or less of the federally established poverty levels is presumed indigent. And then if their income exceeds that, then there's some additional tests and analysis that has to happen here. There's also a financial disclosure form that that is filled out, that's also established by the Ohio Public Defender and the Ohio Administrative Code. And I need to look at it as I'm explaining the situation, but I'll give it to Your Honor at the conclusion. Mr. Saunders does have his sole income, if you will, it's not employment income. It's from a trust that's set up for him over which he does not control the disbursements. He receives $35,000 a year, roughly, which in monthly income is approximately, it's about $2,900, $2,917 a month. And if you look at the eligibility guidelines and he's a single household, it's just him, he doesn't have any dependents. If you look at the monthly income level there for 187.5%, that is above that threshold. 2,228 is the threshold under the guidelines. So then that takes us to the next question of whether or not his net income is below 125% of the federal poverty level, and that requires looking at basically his expenses. So Mr. Saunders.
Dan DeRose with 19 News here. What you're watching is the defense and the state arguing about his income level. And why does this matter is because when it comes time for an appeal, which he's already said he's going to appeal this conviction, it's whether or not he is considered indigent, meaning can he afford his own attorney for the appeal. His staff is his defense is trying to say that he's indigent and that the state should have to pay for his appeal. The state is trying to argue the opposite.
In liquid assets. As far as his expenses, we calculated his expenses as being roughly $1,763. And I will say roughly because he's actually, he's been incarcerated, so we didn't look at any utility bills or anything like that, but this is his best recollection. We tried to be conservative, though. In that $1,763 a month, it does exclude a fee that he pays for a co-op, his co-op fee, and also a mortgage that he pays in DC. And I excluded that because the way you are looking at expenses is basic household expenses. So we only looked at expenses for purposes of filling out or calculating the $1,763 based on the expenses that he pays at his residence in Shaker, which is the residence itself is owned by the trust, who also pays taxes, which also taxes come out of the trust, but he does pay insurance and utilities. And so when you calculate that, including medical expenses, food expenses, transportation, et cetera, that's how we came up to the $1,763. And if you subtract roughly $2,900 minus $1,763, his income falls below 125. The net income falls below 125% of the federal poverty guidelines, which is $1,519. So based on that, our review of his financial situation, the administrative code, and the poverty guidelines, we do believe that Mr. Saunders meets the eligibility for assigned counsel, or in this case, the public defender's office. So I'm just going to provide you a copy of the financial form.
Thank you, Mr. Sweeney.
And then obviously if you have any questions about anything I said or any other questions, please let me know.
I do have a question. You made a comment that Mr. Saunders did not have $5,000 or more in liquid assets. Did he provide you any bank statements in regards to any checking and or savings accounts to establish that balance?
Your Honor, he did not, because we met with him while he was incarcerated. So, obviously we could do a further investigation, but based on representations, basically.
And Mr. Saunders is currently not employed?
He's currently not employed, correct.
And the last time he had employment?
Was it roughly 8 years ago? Or in 2018? Roughly 2018.
And do you know his yearly salary when he was employed?
I don't, Your Honor. 1 second. It was roughly $135,000 a year.
$135,000 per year?
Yeah.
And do you know how long Mr. Saunders held that position with the IRS?
I think that was about roughly 8 years.
Any other employment over the past 15 years besides employment with the IRS?
We did talk about, before the IRS, he worked for some private firms. I can ask him to go over it, but he was employed prior to moving over to the IRS.
And pertaining to the sentencing memorandum, in my review prior to today's hearing, Mr. Saunders has at least 7 advanced degrees. Is that correct, Mr. Sweeney?
He does have several advanced degrees. If Mr. Hurley put that in the memorandum, that's probably correct. He got a number of advanced degrees from Case Western, including an MBA and a JD.
Anything else you'd like to place to the record at this time, Mr. Sweeney?
I don't think so. I think the only thing I'd say is that the trust fund, the trust, which is his sole income, he doesn't obviously control the disbursements. That he gets what is set up in the trust to get on an annual basis.
All right, thank you. Mr.
Thank you.
Mr. Rogowski or Mr. Pateo, anything you'd like to place on the record regarding the determination of indigency regarding Mr. Saunders?
Thank you, Your Honor. May it please the court. The state of Ohio is in a position that we trust the discretion of the court to make a proper determination of Mr. Saunders' indigency at this time. We asked whether the court could additionally inquire of Mr. Sanders or his attorneys as to whether he has any other assets that are liquid or potentially liquidable in the form of pensions, or whether he collects Social Security to that effect. Other than that, we trust the discretion of the court.
All right, thank you, Mr. Rogaski. Mr. Sweetington, just some final questions. Are you aware of any other sources of income for Mr. Saunders? Any unemployment benefits, any Social Security disability benefits, any other assets that have been stated to you by your client in regards to indigency?
Your Honor, we did go over that. He did pay, obviously, he was a federal employee. He paid into the federal retirement system. He has not started collecting on it. It's a relatively small amount because he was there for 8 years. He is not collecting Social Security. And to my knowledge, he has no other income that he collects. The prosecutor mentioned liquidable assets. So obviously, there is the co-op in D.C., but the statute in the administrative code speaks to liquid assets. So the fact that there is something, he also has, a car that, arguably he could sell. But in the analysis of whether someone's entitled to appointed counsel, the existence of non-liquid assets is not something that's factored in the code.
All right, thank you, Mr. Sweetington.
Sure.
All right, I'll take that issue under advisement at this juncture. Moving forward to the motions that were filed by Mr. Martin on behalf of Mr. Saunders. There was 3 motions that were filed. First motion was titled Defense Motion for New Trial, an accompanying memorandum of law pursuant to 33A4. Next motion that was filed by Mr. Martin on behalf of Mr. Saunders was defendant's motion for reconsideration of verdicts and accompanying memorandum of law pursuant to Revised Code 29C. And finally, defendant's motion for directed acquittal and accompanying memorandum of law pursuant to, again, Criminal Rule 29C. Mr. Martin, would you like to address those motions at this juncture?
Yes, Your Honor. The clerk, please. Good morning, Your Honor.
Good morning, Mr. Martin.
The motions that we've made focus on a question of what does 3599.12 mean. This is not a reflection on any paucity of proof by the state. This is not a question that challenges the court's fact-finding in this case. But what it comes down to is this. 3599.12 says you have to vote more than once at the same election. So what does the same election mean? And at the urging of the state, this court has looked to federal statute about the fact that on the Tuesday after the first Monday in November, there are elections throughout the United States in even-numbered years for every 4 years for president, every 2 years for various members of Congress in the Senate. The Constitution of the United States views those as separate elections in each of the several states. And because it views those as separate elections in each of the several states, because the Constitution, and as we've explained in our brief, and Article 1, Section 4, the first clause of the Constitution, recognizes that each state is responsible for selecting its members of Congress, its senator, its electors with respect to for president. And in fact, with respect to the electors for president, there doesn't even have to be an election. It has turned out that each of the states, the Constitution leaves that up to the general assemblies of each state, the legislature of each state, and each state and the District of Columbia have chosen to select their electors through a popular election. But that was a decision that was made by each state. And so the point is this: in our federal system, with separate sovereignty between the states and with dual sovereignty between the federal government and the states, we don't have one election in 2020, in November of 2020. We had 51. We didn't have one election in November of 2022. We had 51. Those 51 were all sending people in 2022 to Washington to be members of Congress or for what was a third of the Senate. And in 2020, it also included sending electors to the Electoral College in December to vote for a president. But they were separate elections. Our legislature used the term the same election. It could have written the statute in such a way as to be more encompassing. It could have written the statute in such a way as to say you cannot vote in the Ohio election as well as the election in any other state. And we know, as we go through the criminal code, that there are other times where the General Assembly has chosen to incorporate the laws and the statutes or the practices of another state. We know that with respect to, for example, the sexual predator laws. We know that with respect to weapons under disability. We know that with respect to sentencing when we're looking at whether or not a person has prior convictions. Our General Assembly knows how to do it. And so when they don't do it in 3599.12, the only inference this court can make is that it was intentional. And as we look at 3599.12A2, it says vote or attempt to vote more than once at the same election by any means, including, and then it goes through including ways that you could vote via absentee ballot. And every single time it talks about an absentee ballot, it cites to the revised code of the state of Ohio and no other state. It could have said Section 3503.16 of the revised code or any other state statute that is substantially equivalent. They know how to do that. They didn't when it came to how the General Assembly drafted 3599.12. So if the Constitution says there are multiple elections, and if Revised Code 1.47 dictates that when a statute is interpreted, it has to be interpreted in conformity with the federal Constitution, we presume conformity with the federal Constitution. What this comes down to is this: the General Assembly, this isn't on the court, this isn't on the prosecutor, the General Assembly did not, at the end of the day, write the type of expansive statute that the state would need in a situation like this. Now, Your Honor's findings at page 11 raise the legitimate question, well, what does same election mean? Does that mean we have to take it down to the individual municipality? Do we have to take it down to the individual precinct? And the answer is no, because there we have the same sovereign. All of the polls that were open on the Tuesday after the first Monday in November of 2020 and 2022 respectively, all reported back to the Secretary of State of the state of Ohio. In Ohio. In Florida, they reported back to the Secretary of State of Florida. In some states, they reported back to the Lieutenant Governor of that respective state. there were a myriad of ways that states ran those elections. Why? Because they were separate elections under the Constitution. And what the Constitution did say was that federal law can regulate the timing of those elections in order to have uniformity, so that we don't have the situation where some states are voting in October and other states are voting in November, because of the fact that that can skew how the November elections are going to be viewed in those other states. It was a matter of administrative convenience. And we've cited to the Hanna case from Arizona with respect to all this, which I realize is not binding on this court, but it's correct. And it's because of those things that what we have at the end of the day is not one election in 2020, but 51. Not one election in 2022, but 51. Run in different ways, different rules with respect to absentee ballots, different times with respect, irrespective of time zones, different times with respect to how long the polls will be open, different people in charge and answerable for how those elections came out. And we even have a couple of states where the November elections aren't the last word. In Ohio, you get elected to the Senate, for example, with a plurality of the votes. In Georgia, as we all remember, there has to be a runoff in December if nobody gets a majority. That's just one example, and we've gone through others in the brief, and I know the court's had the opportunity to look at the brief, so I'm not going to belabor those. That's the essence of this. It's not that the state of Ohio could not have done it through the general. When I say the state of Ohio, I don't mean my friends here in the courtroom. I mean the General Assembly. It's not that the General Assembly could not have done it, but they didn't. And because of that, we have a situation here where Mr. Saunders did not vote twice in the word that the General Assembly chose, the same election. If I could reserve anything else for rebuttal, unless the court has any further questions or any questions. Thank you.
Mr. Rogowski, Mr. Mateo?
Thank you, Your Honor. The state of Ohio, of course, is asking the court to reject the arguments put forward today by Mr. Saunders. The state of Ohio believes that this court properly interpreted the statute that Mr. Saunders was charged under, and that this court gave the plain meaning of the statute that is clear with the legislative intent, the effect, and that if you were to go with the interpretation of Mr. Saunders, it would largely render that statute unenforceable in the context of the activities that Mr. Saunders did, which would lead to an absurd result, which is similar language that you used in your conclusions of law when rendering the verdict. This court cited a federal statute that defined what the general election is. There's also a state statute that the prosecution cited in its closing argument that defines what the general election is. And it reads in quote, "General election means the election held on the first Tuesday after the first Monday in each November." And that definition guides us or directs us to the fact that the general election is held on the same day in every state. So whether it's federal law defining general election, whether it's state law defining general election, or whether it's common sense, everybody understands that to be the same election. And I believe, I understand the separate sovereignty argument that Mr. Martin put forth, but at the end of the day, the result, if you go down that path, leads to an absurdity, and it takes away the plain meaning of the statute and allows for, it's obvious that the legislature wanted to create a statute that prevented the activity that Mr. Saunders did, The state believes he did that in clear language that is understood by lawyers, non-lawyers, the general public, and for those reasons, we think the court got it right, and it should reject Mr. Saunders' sole argument with respect to why the verdict was deficient last week. We believe the verdict interpreted it properly. Thank you.
Thank you, Mr. Kosky. Mr. Martin?
Yes, Your Honor, if I may just have 1 minute. If the court please. There's nothing absurd or irrational about the General Assembly of the state of Ohio saying, if you vote twice in Ohio on the same election day, you violate this statute. But we're not going to get into the interstate business. We'll leave that for other people. And they could have. It's not like there would have been a free pass. In fact, Florida law is broader than Ohio's law. And Florida law, court bears with me for just a second. The Florida statute says that for purposes of its section, votes more than one ballot at any election, those are the operative term, quote unquote, votes more than one ballot at any election. And then it says in, and I'm at 104.18, subsection 2C of the Florida statutes, voting more than once in the same election by voting in this state and in one or more other states or territories of the United States. Florida knew how to do it. And the fact of the matter is that they put it into their statute. Ohio did not put that in. And statutory interpretation is not about what we think the General Assembly should have done. Statutory interpretation is about what did they do, not what do we think they should have said. What did they say? And if there is any ambiguity, then both, and we've talked about this in our brief, then both as a matter of statutory interpretation under 290104 of the revised code, and under the 14th Amendment and the corresponding Ohio Constitution, Article 1, Section 16, as interpreted in the federal case by the Liparata case, any ambiguity has to be strictly construed against the state of Ohio and liberally construed in favor of the defendant. I'm not asking this court to say that in this motion that Mr. Saunders didn't vote twice. I'm asking this court to say, or even that the court approves of anything that it finds Mr. Saunders has done. What I'm asking this court to say is, this is not what the Ohio statute says. Maybe in Florida, but not here in Ohio. And if that causes there to be repercussions where they change the law in Columbus, so be it. But statutory construction has always been about this court having to start with the plain language of the statute, the word same, looking at that word in this, consistent with the federal Constitution, so says Revised Code 1.47. We've talked about that. And then going on beyond that and saying, and if there is ambiguity, Mr. Saunders gets that benefit. And so this is just a straightforward matter of statutory construction. Unless the court has any further questions, I thank the court for its time.
Thank you, Mr. Martin.
Dan DeRose with 19 News. What you're watching here is some pretty good attorney maneuvering, trying to say that because the state revised code didn't say you couldn't vote in 2 different states, like they did down in Florida, that this should be thrown out on a technicality.
And ample time to review the briefs submitted by the defendant in this case, as well as reviewed the trial transcript prior to today's sentencing hearing and any cases that were quoted in the defense's 3 motions. At this juncture, the court will deny the defendant's motions as it pertains to Criminal Rule 29C and Criminal Rule 33A4, and will proceed to sentencing at this time. Mr. Rogowski, Mr. Patel.
Thank you, Your Honor. This court, in its findings of fact and conclusions of law, spoke eloquently with respect to why this statute matters, for why this statute exists, and the harm that statute seeks to prevent. It goes to the core of our country's democratic institutions, and Mr. Saunders' repeated violations of that statute are serious. The question for this court today is, what is the proper sentence for Mr. Saunders? I know that the defense will argue and has cited in its sentencing memorandum that this court does not have the statutory capability of issuing a prison sentence based upon the revised code section 292913, which directs the court to a community control sanction when you have a nonviolent felony 4 or felony 5 for a first-time offender, first-time felony offender, first-time felony offender that doesn't have qualifying misdemeanors. There are then exceptions for when a prison sentence is at the court's discretion, despite the fact that this is a nonviolent, these are nonviolent felony 4 offenses. I direct the court's attention to section VII, so it's B7 in Roman numerals, which does talk about whether the offender has a professional reputation or position, which we believe qualifies here because Mr. Saunders is an active licensed attorney in the state of Ohio, and whether then his conduct either facilitated the offense or was likely to influence the conduct of others. We believe that this court could properly make that finding given Mr. Saunders' position as an attorney, where he takes an oath to uphold the Constitution and uphold the laws of the state of Ohio, and that his voting as an attorney is in other words, an aggravating factor for this court to consider. The state would concede that the remaining exceptions to the rule directing community control for felony 4s and 5s would not apply to Mr. Saunders. If this court were to find that it was statutorily precluded from a prison sentence at first measure, this court has an array of options of community control sanctions and is aware that local residential sanction in the county jail is subsumed under community control sanctions. So to the extent that this court finds that it cannot do a prison sentence, even though the state believes that it can, this court would still have the ability to include a local residential sanction as part of a community control sanction for Mr. Saunders. The state of Ohio believes that one or the other of those is proper in this case, both because of the conduct of Mr. Saunders and because the purposes of felony sentencing warranted. Mr. Saunders voted twice in 2020. That was the initial investigation that came to the Cuyahoga County Prosecutor's Office and the State of Ohio's Attorney General's Office, BCI investigations. Information was provided that Mr. Saunders may have voted twice in the November 2020 general election. Please investigate that and uphold our election laws. That was the task that was given to the State of Ohio's law enforcement team. During that investigation, it was quickly learned that not only did Mr. Saunders vote twice in November 2020, he also voted twice in November of 2022. And the State of Ohio indicted for those 2 years. The information that came from the certified records from Florida and Ohio that this court highlighted also revealed that the states had the state had information that Mr. Saunders also voted in 2014 and 2016. The State of Ohio was aware of that information, believed that it was time barred. The statute of limitations had lapsed for Mr. Saunders illegally voting in 14 and 16. However, the state believes that that is still a proper consideration for this court when determining what the appropriate sentence is for Mr. Saunders, to consider the pattern of conduct. This court characterized it as double voting with impunity for almost a decade. So the seriousness of Mr. Saunders' conduct and the pattern is valid consideration for this court. Also, the state, part of the reason why the state believes that an incarceration, a sentence of incarceration is warranted, is the role of deterrence that factors into any sentence that this court provides, to send a message that this conduct is unacceptable in the United States of America. One person, one vote is a bedrock principle, and sending a message that includes a sentence of incarceration, I think, proclaims that and would be a justification for the sentence that the State of Ohio is asking for in this case. The State of Ohio believes that sending a message that includes incarceration would not only deter Mr. Saunders from doing this again, it would deter others from committing the same crime. And we believe that it's warranted in this case. Thank you.
Thank you, Mr. Rogowski. Mr. Hurley?
Thank you, Judge. Let me preface by saying that I don't pick my clients. I'm grateful that I don't pick clients, that they get assigned to me, and that I try to have a judgment-free attorney-client relationship with every one of my clients, and that has been the case certainly with Mr. Saunders here. I would point out that early on in this process there was a photograph that appeared in the media, and it had me seated next to Mr. Saunders with my eyes closed, and it must be that probably 50 people mentioned this photograph to me and believed that what it depicted was me in a moment of exasperation, that I was so frustrated with him somehow that image was captured on my face. And that, of course, is not true. I mean, you were here when that trial took place, and I will tell you that Mr. Saunders has really been throughout this process engaging with me, and I think hopeful that he has an advocate that is not going to judge him for his conduct. I would also point out to you that he has a peculiar pedigree, you might say. He was born in Manchester. His father was worked for BP here, eventually. Initially worked in London, but then he married his mother, chemist, and they moved to Cleveland. And it was in that life of privilege and affluence that he grew up, and was a bright and intelligent young man, did very well in his academic pursuits, so well that before he actually graduated from high school, he was already starting undergraduate degrees while that case was reserved. He accumulated a lot of degrees there, not only an MBA and a JD, so he certainly is an educated and literate man of letters, I suppose. But at some point after living a life of privilege and working for private law firms in this town, he found himself working for the federal government for a few years. And it was, I think, either this period or slightly around then that his parents both passed away, and now we have this fortune, I suppose you could describe it as, descending to heirs, including him, where he begins receiving this trust money that we've alluded to. I don't pretend to know what kind of a person he was back then, but I can tell you that he was on a lot of medications, prescription medications, ones that might have counter-affecting results. He wound up being unable to work and essentially just lived off of this trust fund and did his best to try to maintain a lifestyle in which he found himself in Florida sometimes and found himself in Ohio sometimes. And it is that split, that kind of physical split, that I think resulted in perhaps even a psychological one of some sort, and allowed him to be under the impression that by voting in the realms that he was voting, he wasn't doing anything wrong. Certainly at this point, he has changed his mind about this and understands and acknowledges that he brought this attention upon himself with his own behaviors that do not conform with all of our understandings of the laws of the state of Ohio and other states for that matter when it regards one simple thing. And this was the thing that I mentioned early on in this process. Residence. Essentially, you're only supposed to have one residence and only be able to vote in one place. And I think over the course of his personal evolution, he just evolved into thinking that he had two residences that entitled him to vote in both of them. Now, it is also, to my belief, important that neither one of the states ever suspended his ability to vote or found him ineligible to vote. And whether he was receiving information from both state secretaries of states, hey, don't forget to vote, hey, don't forget to vote, that in and of itself is a bit of a kind of a maybe a justification in his mind that he was just simply allowed to do what he did. But I think it's worth noting that this law exists to keep everyone equal when it comes to speech. And essentially, Mr. Saunders is convicted now of exercising too much speech. He voted here, he voted there. And that is a kind of an unusual place for not only a client to be, but a lawyer advocating on his behalf. I guess what I would say to you, Judge, is this. This is a crime that is brought ignominy upon him. It is likely going to mean that based upon this conviction that he will be required, and in fact I've encouraged him to self-report to the disciplinary council, and whether or not he has practiced law in recent years or not, it very well may impact his ability to maintain his law license here in Ohio. And that in and of itself is, I think, an important variable that the court should think about when fashioning a just sentence here. I don't think he's ever been in jail before. I think it was certainly a wake-up call for him to have the handcuffs slapped on and walked away at the last hearing. But I will tell you that even in the intervening days, I think that he feels that this court's going to be just in its decision. And I would ask you to grant him the privilege of a community control sanction that assures that this otherwise law-abiding person who hasn't had any other convictions on his record here that we can discern is somebody who is really worthy of what we call a community control sanction. I will not belabor this point too much, but I will say this. I have had poverty lawyer blood in my body since I was born. My old man worked for the Legal Aid Society and defended people who nobody else wanted to defend. And whether it was because they were poor and black or whatever, even if they're white and seemingly rich, it seems to me that every single person in our society gets somebody like me to stand next to him and to make it clear to the court that this is not a circumstance in which sending him to prison, other than perhaps a sensational act that might, act as a deterrent to other bad voters. The fact of the matter is it's, I think, your obligation here, Judge, to look at the man and make a decision as to whether or not that's in the best interests of society and in fact is a just result. I would submit to you he is not only worthy of community control sanction at this point, but I think it is what is required under law. Thank you, Judge.
Thank you, Mr. Hurley. Mr. Saunders, is there anything you'd like to say at this time?
I can't think of anything I'd like to say on.
You don't have to if you don't want to, but now's your time.
I mean, with respect to specific deterrence, I can assure the court that I plan to vote never again anywhere for anyone or any issue. My voting days are behind me. As for general deterrence, it seems, prosecutor might correct me if I'm incorrect, but from what I've read about the Secretary of State's search for people who violated the statute, it seems like we haven't come across too many. I think I'd be correct to say that I'm the only conviction that's arisen on it. So I don't think that there's a whole lot of bad voting that's going on that would be ended by making an example out of me. I think that's all I have to say. Although, if you have questions for me,
Is there anything else you want to say at this time, Mr. Saunders? Is that it?
that's all I have to say.
All right, thank you, Mr. Saunders. All right. Before imposing sentence, the court notes for the record that has considered the oral statements made here today. Court must and has formulated its decision based upon the overriding principles and purposes of felony sentencing, namely to protect the public from future crime by the defendant or others, and to punish the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on the state or local government resources. To achieve these purposes, the court has considered the need for incapacitation, deterrence, rehabilitation, and providing restitution. The court must and has also considered the seriousness and the recidivism factors relevant to the offense and offender pursuant to Revised Code 2929.12. The court must and has ensured that the sentence being imposed does not demean the seriousness of the crime and the impact it has on the victims, and is consistent with other similar offenses committed by like offenders. Finally, this sentence is not based upon any impermissible purposes, namely the race, ethnic background, gender, or religion of Mr. Saunders. As a preliminary housekeeping matter in regards to any potential sentence, I know that the defense is arguing that a term of community control is mandated under 2929.13. Court finds that there's an exception in this case to a term of mandatory community control sanction, that the offender, Mr. Saunders, held a public office or position of trust, and the offense related to that office or position. The offender's position obliged the offender to prevent the offense or to bring those committing it to justice, or the offender's professional reputation or position facilitated the offense or was likely to influence the future conduct of others. Mr. Saunders, you are an attorney. You should be held to a higher standard than an ordinary, unsophisticated citizen. You know what the laws are. You know exactly what you can and cannot do. Furthermore, you're a former federal employee. You engaged in this cavalier conduct and perpetuated a fraud and crime on every voting citizen, every citizen in this country. Your conduct here, dating back to 2014, of purposeful, intentional double voting warrants and deserves a prison sentence. The court finds that prison is consistent with the purposes of Revised Code 2929.11. The court imposes a prison sentence at the Lorraine Correctional Institution of 18 months on count 1. The court imposes a prison term of 18 months on count 2. Furthermore, the court finds that consecutive service is necessary to protect the public from future crime or to punish the offender, and that consecutive sentences are not disproportionate to the seriousness of the offender's conduct and to the danger the offender poses to the public. And if the court also finds any of the following, and here I will find under B that at least 2 of the multiple offenses were committed as part of 1 or more courses of conduct, and the harm caused by 2 or more of the multiple offenses so committed was so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct adequately reflects the seriousness of the offender's conduct. Mr. Saunders, as stated here in court, you violated a fundamental right of this country, that every person speaks with one vote and one voice. I can think of no greater crime committed by a felony of the 4th degree than a crime perpetuated against every single person in this country. These crimes are criminal conduct, purposeful, intentional, cavalier, warrants this lengthy prison sentence. You are sentenced to 36 months in prison on these 2 counts. Furthermore, I'm going to issue a fine on each count of $5,000. I will find that you are not indigent on the redetermination of your indigency, and I will order you to repay your attorney fees to the Public Defender's Office. Furthermore, I will find that you are ineligible for future legal services from the Public Defender's Office, as this court is finding that you are not indigent. Upon completion of your prison sentence, Mr. Saunders, you may be subject to a term of post-release control for up to 2 years, as determined by the parole board. If this period of post-release control is imposed following your release from prison, if you violate conditions of that supervision, the parole board may impose a prison term as part of the sentence of up to 1/2 of your stated prison term. You may also be charged with a new offense called escape, another felony where you face additional prison time. If, while on post-release control, you are convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional consecutive prison term of 1 year, or what time remains on your post-release control term, may be added as an additional consecutive penalty. While on post-release control, you may not ingest or be injected with a drug of abuse. You will get full credit for the time served. Since the verdict, you have 6 days of jail time credit. Anything further, Mr. Rogowski or Mr. Pateo?
Nothing on behalf of the state, Your Honor. Thank you.
Anything further, Mr. Hurley or Mr. Martin?
Yes, Your Honor.
Yeah, I would just say, first of all, Judge, I understand you have ruled that he is not indigent, but at this point, he certainly is entitled to appeal the court's decision. I would suggest that if he is going to be serving the sentence here at this point, that would now officially render him indigent for purposes of appellate counsel. And if it is of your mind that we're not to represent him in that capacity, I guess I understand, but I would ask that this court appoint him appellate counsel at this time.
Thank you, Mr. Hurley. Mr. Martin, anything further?
Yes, sure. We move for bond pending appeal. In this case, we believe that there are substantial issues on appeal, and that it would be appropriate in this situation pursuant to statute for bond pending appeal.
The bond for Mr. Saunders will be denied. Thank you.
Thank you, Judge.
Mr. Saunders, you are remanded to the custody of the county sheriff. Sheriff will be ordered to transport you. Court is adjourned.
Dan DeRosa with 19 News. This judge is not messing around in this voter fraud case. He found Saunders guilty of 2 counts of voter fraud. That's voting in both Ohio and in Florida. We found out today in court that this goes way beyond just the 2020 and the 2022 general election. Apparently, this goes back to the 2014, 2016, but because of the statute of limitations, those charges were thrown out. The judge saying that he is nobody special just because he has 2 residences doesn't grant him 2 votes, that it is 1 vote, 1 voice, and that this is a crime committed against all voters across the entire country. Again, the judge sending a message. He could have given him post-release control, could have given him probation instead of sending him to prison. That's not what he did. He gave him 18 months on each of the 2 counts. He could have let him serve 18 months, have them gone concurrently, meaning they get served at the same time, so he would get a year and a half total. That's not what he did, the judge making them consecutive so that he has to go to prison for 3 years. Again, you just watched a judge send a clear message, even though his attorneys tried to say, well, wait a second. If you vote in an election in Ohio, isn't that separate from voting in an election in Florida? Because they're run by different governments, they're overseen by different officials. So isn't that technically 2 different elections? We see Cuyahoga County Prosecutor Mike O'Malley coming to the podium. So let's take a listen in on what really was a landmark decision.
And just tell us how you feel about this.
Well, as the judge indicated, this isn't just a normal criminal defendant. This is an individual who was a licensed attorney in the state of Ohio who knowingly voted in multiple states in the same election repeatedly. He was convicted of 2 separate elections voting for, but historically we know he did it at least 8 times. I thought the argument that the defense made that Ohio's statute is not worded sufficiently, which would enable any citizen, if they had enough wealth, to own perhaps homes in 50 states and be able to vote in 50 states in the same elections, as Mr. Golski indicated, is an absurd argument. And I think the judge sent a message. Occasionally we will get notification from the Secretary of State that there might be people registered in 2 states, but we've really never had an example where somebody actually is registered and votes in the same election. So he was a certainly unusual individual, and given the fact that he's a licensed attorney, knows better, and repeatedly did it, I think was sufficient grounds, as the judge indicated, to have him incarcerated for 36 months. And as the judge indicated, he found he was not indigent. So it's my expectation now he's going to have to dig into his trust funds that he receives every month and hire an attorney. And if he believes he's been wrongfully convicted, he has the opportunity to try to fight that. But it appears to me that Mr. Saunders, as the judge and his defense counsel indicated, is a person who came from a very affluent background of considerable wealth, well-educated, and he basically thought the rules didn't apply to him. And I think today he realizes that they do apply to him.
Yeah, I asked earlier during the verdict saying, is this just him? Do you think that there's more people out there? Do you think it was something where he had a bunch of people doing this with him?
No, you know what? The Secretary of State, and again, I want to, Andy Rogalski, Brendan Pateo did a wonderful job on this particular case, but we routinely, perhaps a half dozen every year or 2, get notifications from the Secretary of State that we have people who may be registered in multiple states. So the Secretaries of States are trying to weed out potential individuals who may commit fraud. But we have not had them. And oftentimes what you'll see is maybe somebody moves from one state to another state and they didn't deregister in another state. Or we've had examples where they think it's the same person, and then through further investigation, we learned somebody named John Smith is not the John Smith in another state. So there are multiple examples we have had where it's actually not the same person. But again, this is really the first time that I recall where we have somebody blatantly defying election laws. And again, I just thought their argument that the statute wasn't written well enough where he wouldn't know any better, and the argument that he could vote in 50 separate states if he so chose was just, it was ludicrous, and it was absurd. And obviously Judge Santoli shot that right down.
With that, is 36 months enough?
You know, I try not to comment on sentencings. None of these things are easy, but I think, and I don't want to speak for the judge, but I think his message is that you are a licensed lawyer in this state. You know the law, and you defied it knowingly, intentionally. And so I think the judge held him to a standard that you should hold to a lawyer, that you know better, you're a lawyer, you did this intentionally, you did it repeatedly, and now you're going to be held accountable. So I think the judge did what he felt was appropriate, and I'm not going to argue with that. I think he did what was needed.
The other thing I'd add to that is that 18 months for 2 felonies of the 4th degree is the statutory maximum. The judge would not have had the power, the ability to go any higher than 36 months. So in our terms, he received a maximum consecutive sentence for 2 felonies of the 4th degree. Whether or not the penalties for this crime should be higher is a different question, but Judge Santoli, that obviously sent a message that with a maximum consecutive sentence here, he showed how serious he believed the crime was, and that was warranted in this case. So I wanted to add that so that the public was aware of that context.
Right. And again, much of the information that was further dug up was a result of, as the process of going to trial in this matter, we dug up further and further and found out that there was multiple incidents that were outside the statute of limitations where he had done this previously. So again, this isn't a one-time situation where maybe somebody had forgotten. You don't forget like this. And so the message is clear, is don't commit voter fraud in Ohio.
And then you said this is the first kind of case they've had like this?
In my recollection, this is the first time I recall where we actually had somebody vote multiple places, multiple times during the same election. And yeah.
Dan DeRosa with 19 News as we wrap this up. So if you have any friends that are out there saying, oh, people vote multiple times all the time, you just heard it from Prosecutor O'Malley. This is the only case that he can recall where someone was blatantly voting multiple times. So if you can't trust the Cuyahoga County prosecutor to say that this just simply does not happen, there are checks and balances to make sure that people don't vote multiple times, even in multiple states. This is the only conviction that he can remember happening because of someone voting multiple times in multiple states. Again, the judge sending a message. This is the maximum penalty he was allowed. We're going to wrap this up. If we have any other breaking news, we'll bring it to you here on our digital properties. Until then, I'm Dan DeRosa with 19 News Now. Have a good afternoon.